Good morning, everyone. My name's Stacey, but I haven't met you before. I work here in the team with QCOS as the Executive Director for Sector Workforce Planning and Development. So welcome. If you haven't been part of this network before, it's really exciting to have you here, and we've got a great agenda set out for today. I'm going to begin by acknowledging the Yugambeh speaking nation. I am working from home today, and I live and raise my family on their land. I'd like to pay my respect to their elders past and present and acknowledge their continuing connection to this place and the care of this place. Of course, extending that acknowledgement to any First Nations people we have on the line this morning. And I would encourage you to acknowledge the country that you're on. In the chat. It's really great for us to see the breadth of the countries that we're on whenever we meet in this online space. So I encourage you to do that if you can. So for anyone who is new to the network, thanks for coming along. This is our technically our fourth meeting for the year because as you will have noticed, if you're engaging in particularly in the human rights and advocacy space, there's been a few consultations and reforms going on, and so we have had a few snap meetings in between our scheduled meetings to accommodate for consultation on those. And this space is really designed to be a place for peer discussion and support as we consider how we use the Human Rights Act in our work across the community service sector, which is really broad, which has a lot of different service delivery types and advocacy organisations. So this is really an opportunity for us to discuss human rights and what it looks like in our everyday practice, but also how we can engage in systemic advocacy and that broader work that really has quite an impact on the frontline service delivery that we see and the experience of the clients and service users that we're working with every day. This network we have bi-monthly scheduled meetings, but as I mentioned, we have been meeting in between those scheduled meetings to accommodate for participation in different consultations that are happening. This network is really built up of people who are very well versed in law, in human rights, as well as people who are really just starting to engage in this work. So if you're newer to the work, I encourage you to bear with some of the terminology that might be new to you. This really is a space for discussion and participation in conversation. And so even if some of that terminology and some of what's being discussed is new to you, I really encourage you to stick with it and ask questions, because we're really happy to engage in the discussion and bring everyone along with us while we use human rights, the Human Rights Act in our work. I also would encourage you to consider what you're hearing. You may have noticed that we're recording the session today, and we always do our best to distribute recordings where it will add value and where people have asked us to distribute it, especially when they're not able to attend. But I would ask you to consider the sensitivity of some of the topics that we might discuss in the Human Rights Network, and whether or not they're suitable for discussion outside of the meeting itself, and that you're using the things that are discussed for the good in for the work and for discussion with your peers and colleagues back in your own organisations. As far as housekeeping goes, please feel free to utilise the chat. We've got a few QCOS team members on the line. You'll see them because they've got their logos behind their heads, that will be managing the chat. But also feel free to take yourself off mute. As I said, this is participatory. Feel free to jump in, ask questions and to clarify things. Now, I'm going to hand over very soon to our panellists. We've got some really exciting panellists today. It's a real pleasure to be joined by these three individuals to talk about their own experiences in using the Human Rights Act in their work. Now, when we talk about advocacy, we're talking about advocacy quite broadly: legal advocacy, non-legal advocacy, and systemic advocacy as well. And depending on your own work and the organisations you are working with, you may have different aspects of advocacy that you're quite interested in. So we hope today will give you a real breadth of experiences across the different organisations and what they do, and we'll have a few questions to pose to them after they've had a chance to talk to us about their own role in advocacy. So we have got on the line Bridget Burton, the Director of Human Rights and Civil Law Practice at Caxton Legal Centre. Hi, Bridget. Thank you. We've got Julie Bartlett, a solicitor at Tenants Queensland. Thanks so much for joining us, Julie. And we've got Rebecca Anderson, a senior solicitor at ADA Law at ADA Australia. So I'm feeling really lucky to hear from these panellists today. And without any further ado from me, I'm going to hand over to you, Bridget.
Hi, thank you. Well, my screen just updated with everyone's faces. It's an alarming development. So I am the Director of Human Rights and Civil Law at Caxton Legal Centre. I look after a large team of mostly lawyers. In that section, we use the Human Rights Act and other aspects of human rights in our advocacy, both directly for clients, systemic advocacy, for in the law reform work that we do, in the community education that we do, and as public entities.
Thanks, Bridget. I might throw over to you, Rebecca.
Hi everyone, so my name's Rebecca Anderson, I'm from ADA Law. ADA Law is a community legal centre and our focus is on people with questionable capacity or someone is challenging their capacity to make their own decisions. So we work with clients in QCAT, MHRT and EPOA issues. And we only ever act for the adult who's having the question raised about them. So we don't act for family members, we don't act for other institutions and other people, so that our focus is wholly and solely on the person being challenged. And what we do is that human rights underpin everything that we do, so that we're focused in on what the person's trying to achieve for themselves, and we're there to help them and to facilitate as much as we can. Thanks.
And Julie.
Hi everybody, I'm Julie Bartlett. I'm the Principal Solicitor of Tenants Queensland. I look after the legal services team within Tenants Queensland, which consists of 4 solicitors. Tenants Queensland also operates the Q-Stars program, which consists of about 50 other workers, mostly paralegals. And yeah, we have engaged with the Human Rights Act from the beginning when it commenced, in early 2020. I think that's when it started, although it was passed in 2019. I remember my first case was a hoarded case, which didn't really go anywhere because we didn't really know how to engage with the human rights legislation, and also because of tenancy law, the time limits are quite strict because this was a termination due to hoarding issues. It was quite difficult because the time limits don't, within the Human Rights Act and the complaint system, don't allow early engagement within the Commission. So I think it did eventually enter the Commission at some stage. However, we weren't involved at that stage. The tenant had taken it themselves to the Commission. So we use it in our law reform submissions. We do in-house training with our workers. We have developed sample products for our workers to use with tenants. It's something that we find a tenant can't really take a sample letter and write it themselves. They really need assistance in understanding the legislation or scaffolding, in understanding how their rights, because of the way the rights are written, and it is a bit interpretive. It's not one size fits all. So we feel we have to scaffold a complaint or an issue for client to get the best outcome for them. So we do use it in various stages of our tenancy matters, and we also use it with complaints that go straight to the Commission that may have a discrimination issue as well as a tenancy issue. So yeah, thank you for having me, and I think this is my first time at one of these meetings. Thank you.
Thanks so much, Julie. And you've brought up a really important point. We were speaking to QCOS was speaking to an organisation earlier this week about their use of the Human Rights Act in advocacy for clients, and that point did come up around having that the context required to actually use tools and resources. And while they are very, very helpful and are enablers to this work, that having that contextual knowledge is critical. And so having organisations such as Tenants Queensland or other organisations being able to provide that context is really important. Bridget, I might come over to you again and ask you what it's really been like to engage a new tool in your advocacy. So Caxton Legal Centre has obviously been established for a long time and supporting service users and clients to protect their rights even without a formalised Human Rights Act. So we talk about a human rights framework for viewing the world. That's really been at the heart of what Caxton Legal Centre has been doing for a long time. What's it been like to actually have the Human Rights Act as a tool?
Oh, that's a really hard question because it's hard to judge it against our existing advocacy that we did before. So sometimes I think that the critical kind of component of a lawyer's work is more around like persistence and the way you go about fighting for a client, regardless of what legislative tools you have in your basket. And we have always used all of the law available to us. So for our clients, and we still do that, we're not narrow to a particular area of law. What we do is we look at it, the person's situation with as much law as we have in our heads, and try to find the right or best way forward for them. So we've always had a focus on human rights. We work substantial. I work and have done for a long time with the anti-discrimination law, which is a piece of human rights law, and with the federal anti-discrimination regime, which a lot of those pieces of legislation are dropped down out of the various international instruments that provide for human rights. So the addition of the Human Rights Act has been helpful in the sense that it gives language that I find clients can understand about their human rights, and it's language clients were often already using themselves. It's also been useful in terms of articulating for decision makers how they're meant to be applying human rights in their decision making, whereas previously that was a bit of a battle for us. Like, we could identify where human rights were coming into play. We could identify some other law that might have supported those rights, but we kind of lacked a structure for raising those issues with people outside of like formal reviews to Supreme Court or something like that. So it's given us a way of structuring how we talk about human rights more than it has given us rights, because obviously we already had those rights. Everybody already had those rights. They just weren't in law in Australia, or they weren't written down in the way that they are now. So I think that having the Human Rights Act has allowed us probably an easier way to have conversations, with the same conversations that we were already having, but a bit more structure around that and around what we're expecting to see on the other side. And that really comes from the fact that the Human Rights Act gives real steps to consider weighing human rights against other things when you're limiting rights. And that's where I think we've probably found it most useful. Did that answer your question?
Yeah, thank you. Yeah,
it's Rebecca here. Sorry, I was just gonna say, yeah, we've been pretty similar to that. We've always championed human rights, but didn't have anything to hang it on, and so organisations could always push back and say, "You're just talking airy fairy stuff." You know, we had to do this duty of care and so forth. And so the Human Rights Act landed us somewhere where we could say you're obliged, because you're a public entity, to comply with such and justify your actions and so forth. And so it's forced the organisations that we work against to have to challenge their practices and processes and think about their actions themselves.
That's really useful comment. Thanks, Rebecca. And I'm wondering, coming from ADA Australia, whether on what you would think about the value that might be in a national approach to human rights.
Well, for us, we're always up against the aged care sector, and so and the NDIS sector, and so both of those organisations, you know, service providers, aged care workers, and so forth, they can all say, well, the Human Rights Act's all well and good, but it doesn't apply to us.
Yeah.
And so, being a federal act, it captures that cohort as well. We have clients that are getting issues with state agencies as well as federal agencies, and we can help them a little bit with one but not the other because of that lapse. So for sure it'll help with closing the gap in that space, I believe.
I think
sorry.
I was just going to say, with the Federal Act, following on from what Rebecca was saying, I personally think we would have had a way of dealing with robo-debt much earlier if we'd had a Federal Human Rights Act. It would have been a mechanism by which people could have thrown light on that problem. And I had a experience last year of bringing a case and then the government changing the law to override the impact of that case. And one of my ex-colleagues at the UQ said to me, "But Bridget, that's the whole point of the human rights law. It's to bring things into the light. You don't necessarily get to control the outcome. Your job is to bring things into where it can be seen." And I think that if we'd had a federal Human Rights Act when people were going through all of that robo-debt horror, it would have, if nothing else, given us a way of seeing that as a community and having that bought out much earlier and hopefully with a lot less impact on individual people. So I think when we're thinking about federal law, the disability and age stuff comes obviously to the front, but I think if people want an example they can relate to, I think that the robo-debt situation is something everybody knows was wrong, and maybe that's something that would be different.
I wanted to remind people too, if you've got questions or comments to make, please put them forward. We've got some questions here to be posing to panelists, but really happy for you to jump in with your own questions and comments as well. Julia, I move over to you now. You touched on the fact that when the Human Rights Act first came in as an organisation, you hadn't yet digested all of it, understandably, and so weren't able to use it in some of the first robustly in some of the first cases when it first came in that you were dealing with. Can you talk about perhaps what have been some of the enabling factors in your organisation to using the Human Rights Act? So some of the things that you've done, you did talk about training. What are some of the things that your organisation has in Tenants Queensland really engaged in to enable that?
We engaged in forums like this. So at the beginning, there were many discussions about how to use the Act. The Human Rights Commission put out their own resources on the website and they deliver their own training. We use the pro bono legal sector to get some in-house training, and we took that on board and continue to deliver it and develop our own resources. As a new tool, it was very hard to get non-lawyers to feel confident using it, and it is still difficult. You know, we've got a lot of paralegals here, so we do have an internal help desk system where we do help each other internally, and we don't expect everyone to become an expert. So we have some workers with more knowledge than others. So we have a lot of information sharing in that space, and we have created our own internal precedent register. You know, we have used resources, you know, the Victorian and the other states, ACT, have their own case law and resources, and we have used those to try to see how we could bring them into Queensland, or see how creative they were. And I have used a few ideas in my work, especially with clients experiencing domestic and family violence, you know, tenants, obviously, and I had a particular tenant who was also sleeping rough or sleeping in his car and was constantly moved on. So he's an ongoing client of ours. So we're looking at how other states use the Human Rights Act to help those clients. We've also use the advocacy in, I guess, law reform when we're writing our submissions, like I touched on, and we do read how the government, you know, before they bring in draft legislation, how they consider the Human Rights Act, or, you know, sometimes they put a little statement saying they consider the Human Rights Act, and a few times we've gotten opinions on how we can challenge that, especially in relation to in tenancy. I'm not sure if everyone is aware that there was without grounds termination provision, so a lessor or agent could terminate a tenancy without grounds, and we wanted to hold the government accountable, because although the housing and homelessness isn't a specific, you know, housing, the right to housing, the right to security, housing security isn't in the Human Rights Act, there are other ways we could creatively use the Human Rights Act and hold the government into account in that law reform stage to try to get a change in legislation. So they brought in these other grounds. They brought in end of fixed term, which we are still going to challenge. It's not good enough, but it just created some movement in legislation. So the frustrating part is it's very piecemeal. You think you've got to win, and we thought, great, things are going in front of QCAT, but they're not getting published. Very few cases in QCAT are getting published, especially in the tenancy space. And the other, you know, whilst we want to use it in advocacy, the other part is getting the other entity, the public entity, to respond to the complaint, because there's 45 business days, which is a very long period. And in tenancy, we've got very, very short limitation periods of a 7-day notice to leave and a 2-week application to QCAT or termination. 45 business days isn't going to cut it. You're not going to get that complaint dealt with. So the way we used a complaint was try to get an adjournment. Often it would be an adjournment for the parties to discuss the human rights complaint and see if there was some other mechanism other than to progress with the termination. Because our public entities were mainly Department of Housing, community housing, maybe NDIS providers. We were also looking at the Queensland Police Service in relation to move on powers, etc., and even the local councils in relation to a few of their powers. So, yeah, it is very piecemeal, but I think it's worthwhile chipping away, and it is frustrating when you occasionally get that member in QCAT who says things like, well, the Human Rights Act doesn't apply to me. I don't need to consider it in the decision. So you get an adjournment and then you write a whole list of submissions as to why they need to consider the Human Rights Act, where their jurisdiction and where their powers lie, which does take up a lot of our funding. You know, we're funded to help tenants, but there's this additional area. Maybe each CLC needs to be funded to have a human rights expert, because the government's introduced this legislation and it's kind of doubled up our workload, because we're essentially educating the public entity. I remember, sorry about going on, I remember when the Department of Housing first had to deal with these human rights complaints, they set up a panel. They had a panel of 4 people, I think. So the complaints went to this panel system, and now it's no longer there. The complaint just goes to their area office. So it just goes to the address of the area office. It used to have to be escalated, so I'm just not quite sure where that change happened or how that changed, or whether they're not taking it as serious as they had done at the beginning when the Act first came out. So yeah, there's been a few. Pardon?
Sorry, I was just going to say, if I can just, following on from what you've just been talking about, Julie, I think you've hit the nail on the head there, is that the organisations, if they don't want to embed human rights in their practices, then it falls on all of us as community organisations to champion the Act, to educate, try to change, try to improve practices and so forth. And so it really is a cultural shift that's required from a lot of organisations. Some organisations have taken with that and are certainly saying, you know, at least saying that they've looked at the Human Rights Act and they've applied it in their decision making. Others don't even recognise that it exists, and it's a daily battle for us on the ground with, you know, this Human Rights Act. You know, it actually does apply to you. Can you show us how you've used it in this action that you're doing? Typically for us, it falls around, you know, their duty of care. And so that's what they're always championing, is if that has more weight than the Human Rights Act and the impetus on the person. And so it's always about us having to educate those organisations and try to improve their culture and practice, unfortunately.
Yeah, I agree. I almost think there needs to be some sort of a type of reverse onus of proof, like when these public entities make a decision, they need to provide some sort of justification, especially if it's a life-changing decision, such as a termination into homelessness or some decision that actually puts your client at risk. They do give you very bare minimum. We've considered the Act, but they don't go through what other things they've considered or why they've rejected other avenues they could have pursued.
You've highlighted a few things there. I can see Bridget would like to say something.
I just wanted to reflect on what Rebecca was saying about the weighing up that goes on in government departments between safety and human rights, and how we've actually found that that's probably the biggest problem. Is there's not a very fair weighing going on between what one public servant's view of safety is, which is often self-protected of themselves, and the human rights of the person they're making decisions about. And this whole idea, we were really hopeful when the Act came in that it would improve this dignity of risk kind of thing, where people would be allowed to just do things and make decisions that were a little bit incorrect, like the rest of us do. And that we thought the Human Rights Act would give people a structure, and it does really give people a structured way of balancing safety against rights and self-determination and things like that. But we're finding that's where it probably falls over a little bit as well in people's considerations. It's really a constant battle with the government to get some headway into an acceptance of risk. And one example of that is that we will often use it to say police shouldn't have interacted with a person in the way that they did. And then the response is always, but what should have we done? And we say nothing. You should have done nothing. You should have just kept on walking. Like, why interact? Your interaction has then led to further intervention, which has ended up with this person being arrested and then charged and spending time in the watch house, and like this cascading thing. And their view is, but I had to do something, and that I had to do something, it pervades across. And that's where I think that we're having a little bit of difficulty.
Queensland Health would probably be guilty of that as well, intervening in someone's life choices and discharge planning and so forth. But you're right, absolutely.
I think as the Act matures and people's understanding of it matures, hopefully that's where we're headed. That's where I would really love to see us headed. and you see little glimmers. Like there's a recent decision in health to start offering people the option of a home birth. Like that's a real dignity of risk kind of scenario where you can see that there's been a bit of a balancing against those things more fairly. And I think starting to see those kinds of decisions being made in other areas would be so great. And it is a real challenge. A real challenge.
You've kind of led now, Bridget, onto one of the questions that we prepared, which is around, and I know that there's some questions in the chat. I will come back to those, but just because you've mentioned this, I'll go in this direction. We'll come back again. But how do you see advocacy developing in Queensland? You did just talk then about the sector really developing the maturity around understanding the human rights. I'll ask this to all three of you. How do you see that developing over time?
I mean, I can say I've already seen changes. So initially we were the same place that Julie was at, which is really educating. I mean, I would have spoken to dozens of government departments, none of which we received any funding for, to try to help bring along understanding. So our advocacy was really direct and supportive initially. It's probably gotten a little less supportive and a little bit more, hey, you should know this now. Let's see you actually do things differently. And I think that, you know, there's been some interesting developments, I guess, in case law that have come through, which have really been focused on that basic obligation to consider human rights. So that's the first step, like consider human rights. A lot of the wins that are coming through in the law are that there's a failure to consider human rights, not even whether human rights have been, you know, what rights are engaged, what proportionality and how it all works. It's just that utter failure to consider. Now, hopefully that those couple of cases have been a bit of a wake-up call, and that we can move on to having substantive conversations about how human rights are being limited. But at the moment, we're still, I guess, yeah. So that's where I would hope that we're heading. We've done the education piece. People are starting to consider human rights because the courts have been telling them, hey, you've got to consider human rights. And then hopefully we can move on to how those human rights are being weighed against other things, which is what Rebecca and I were talking about being a really struggle for us at the moment. That's my hope.
It's good to have hope.
Well, you know, we're only really a couple of years in, and our Human Rights Act was deeply affected by the COVID that happened almost simultaneous with its implementation. And we're only starting to come out the back end of that to see how those things should have fit together and how they did really fit together. So I think we can cut ourselves a little bit of slack in terms of maturity.
Yeah.
But yeah, the next stage is really, hey, I've gotten into section 13, which is the proportionality analysis, and here is how I proportionately made my decision to limit your rights. We're not seeing any of that yet, and hopefully that's what's coming.
Great. Thank you, Bridget. Rebecca and Julie, how do you see advocacy developing in Queensland?
So we are seeing some improvements in government agencies' engagement with us as an organisation and with our other agencies like us. There's some conversations happening about, you know, what should we be doing and how could you suggest improvements and so forth. So at the top levels, they do seem to be engaging with this conversation and this topic. Big organisations, obviously the challenge is how do they filter that through to practice? And you know, we get inquiries from, say, Queensland Health probably weekly, if not daily, and we can work with one person at the ground level and improve their practice and their knowledge. But unless it comes from the top down, it really doesn't get bought into. It's the rogue operator who's out there, you know, trying to do best practice and so forth, and they're working against their machine. And so for us, we've seeing cracks at the top level where they're willing to engage, but we need it to be drip filtering through all of their practices, all of their directions to staff. And what really needs to be recognised, and this is where it gets uncomfortable for them, is that it can take time for best practice to work. And so they're looking for expediting outcomes, right? They're looking for discharges. They're looking for get this person through corrections, serving their time and so forth. So they're looking to get through the system. But actually facilitating someone's access to their human rights can slow that down. And that's something that the system doesn't really want to see. So that's a challenge as well. The sorts of tools that we work with our agencies is around supported decision making. So that's teaching agencies and people in the community how to implement the legislation so that you get good outcomes for people with the least impact on someone's human rights, because some people need support. And so we're trying to teach them how to do it in practice. And the truth is, it takes more time for a single person to be assisted in a holistic way, which has least impact on their human rights, is a longer, slower journey than if we just cut to the chase, make the decision, move them where we think it's inevitably going to go. And so that's the challenge, I think, for the agencies, the funders, the Treasury, to recognise people lay in hospital for longer than they should. People are displaced from homes and so forth far longer than they should. People are in corrections longer than they should. All of these are all consequences in some way.
Really good points. Thank you, Rebecca.
I agree with both Rebecca and Bridget. I'm seeing the same thing. The first step is to get those decisions where I guess the entity or our entities, Department of Housing and QCAT are the main entities, recognise that the Human Rights Act applies to them, and essentially proceed from there. We're finding it again very piecemeal. It would be good, because I was looking at policies from various government entities or public entities to see it interwoven a bit more within their policies and procedures and decision makings. We look at the Department of Housing's procedures manual in how they make decisions, and there's not one reference to the Human Rights Act in the whole decision-making process, whilst in their complaints policy, they do talk about the Human Rights Act. So maybe they need to do a lot more education internally and rewriting of a few of their policies to include the consideration of the Human Rights Act in all decisions that can affect an individual to the extent it does. Yeah. So,
yeah.
And the recognition of public entities of our sector is becoming much better. Before, it used to be who is a public entity. So people just know now intuitively that, these organisations are public entity, maybe we should declare ourselves a public entity. So that's the next step for other organisations that are a bit in the grey area, just declare themselves. I think, Caxton, you declared yourself a public entity recently, yeah. So
we've opted in.
Opt in. So it's that could be another shift, so to make it a bit more clearer for the sector.
Bridget, thanks, Julie. Bridget, did you want to briefly touch on Caxton's decision to opt in?
Well, I think it was important for us because we'd been part of the campaign for the Act in the first place to kind of put our money, I guess, where our mouth is and opt in to that process. It was hard, actually. So it was probably, a year's worth of work for us to go back through our processes and say, is this the human rights approach to this decision? What would be a better way of doing that? one of the challenges that we had, which a lot of non-government public entities would have, is that we don't have resources to meet demand. And so we are making rights limiting decisions constantly. And that rights limiting decision is, we're not going to do anything else for you. And my team are making that decision for around about 100 people a week. No, this is it. You get the piece of advice, and then you have to go and help yourself. And so that's a lot of work. And what we didn't want to do was spend all of our resources saying no better, which I think is something that can happen. And I worked at Legal Aid for a while, and I think that Legal Aid has all of that structure around saying no. There's no way a community legal centre could put all of that structure around saying no. So we had to go through quite a complicated process internally about understanding, well, what resources we had, who our clients are, how to best allocate those resources so they have maximum reach, getting really good, clean policy around the allocation of limited resources so that we could make decisions quickly, defend those decisions coherently, and that we knew that we were making decisions in line with rights on every occasion. So that's been a really difficult exercise, and sets us apart, I guess, from government agencies who do have the resources to do the work that they do, even though they tell you that they don't, they do. As we all know what it's like to actually not have the resources to do the work that you do, which is in fact turning away 97% of the people who come to you for help. There's not very many government departments that are having to deal with that kind of turn away. So that was a really challenging process for us. Really good, lots of soul searching. And I think we've got really good systems now, but and I would strongly encourage organisations to go through that process. Even if you don't have to go through it, you will become a much better version of yourselves if you've really given consideration to the sorts of things the Human Rights Act asks of you.
It sounds like fairly grueling, but as you say, worthwhile process.
Yeah, it's just that when you've got an organisation like ours been around for 40 years, there's things that you do that you've done for 40 years that no one's ever really given consideration to. So one of those things was we would have people call up on Monday to make an appointment for the week following, and we'd fill up halfway through Monday. In some areas of law, we'd be full for the week after. And then we would just tell everybody else who called in that week, I'll call back next Monday. And then on Monday, the phones would go absolutely bad, and we would just book in the first however many people that got through. And then everybody else the rest of the week got told call back next week. And that was a cycle we've been in for like 40 years, literally 40 years of doing that way of booking appointments. And then we went, but hang on, first in, first served is really not a human rights approach to allocating limited resources. This is just not defensible in a human rights framework. And so we had to go right back and have another look at how we approach these kind of things. We've been doing for a really long time. Which I think ultimately we're much better at the end of that. But it's challenging, especially if you have an organisation that's been around for a long time, has an established role in the community, it's kind of institutional and does things a certain way. To have to change that, big deal.
Yeah, that was a really great example, Bridget, of a consideration an organisation can make that's not a radical or, well, not necessarily needs to be a radical change that your organisation can make, but really practical, simple considerations if we do unpack our everyday processes as an organisation and the way that we operate. And like you say, until someone stops to really unpick it, it's just something that, as you say, can go on for 40 years without anyone really questioning it.
I'll give you one other quick example before I let somebody else talk. The other thing that we decided to, so we started out saying, well, we need to identify our target clients. We have to be asking people all of these questions about their vulnerability when they call up. And then we thought, that's not right. That's not the human rights approach. What we need to be doing is having hard conversations with our non-clients. So let's ask people how rich they are instead of how poor they are. And we started having difficult conversations with the people we're not helping, rather than So it was much more about identifying who is not our clients and making it really clear on that website for those people so they could not call us. But to be when we did have those conversations, the hard conversations were with the appropriate individuals. So part of that was introducing an income test for us, but it will look like different things to different organisations. But really focusing on the dignity of our core clients and the privacy of those people, and thinking about how we could move on those who can be moved on, so to the private sector, without further impacting the rights of our clients in those initial conversations, was a really important part of that process for us too.
Great, thank you. I'm going to give you, the three of you, a little warning that I'm going to finish off the panel with asking you to share with us a key learning or a really positive example of whether it's systemic advocacy or a client, a little anecdote you might have about where you've really seen the human rights add value to the work that you're doing. But I'm giving you that now to plant the seed, but I'm going to come to the chat. Because there's a few questions here. We might not get to all of them, but let's have a look at what we've got here. And again, to everyone on the line, keep bringing your questions, and if you'd like to ask something. Asha has asked, Bridget, with Robodebt, which right would be engaged there or breached there?
So it's not so much about which right, because there'll be a number of them and it will depend on how they craft that federal law, but it could easily be things like the right to privacy or equality before the law, things like that. Where the value comes in is in that duty to consider a person's human rights when making decisions. Now, one thing we know about Robodebt is that no one thought about anything. They just plugged some numbers into the database and some paperwork spat out the other end. So a duty to consider a person's human rights is where I think that that you start from, and then to act compatibly with those, it requires an engagement. So that's why I use that example, is because it's procedural, and that's where we've really seen the Human Rights Act starting to come into its fore in Queensland, is procedurally. So I think that that's where we would see the benefits initially, and then it'd be depending on what rights you have in that legislation. It could be cultural rights, it could be privacy, it could be family and home, it could be lots of things that come into play, but the duty to actually think about those would have made a big difference.
Thanks, Bridget. May has asked, thanks for your question, May, and I love your earrings, by the way. Have you found that clients are coming to your organisations with better information or stronger or further developed cases since the Act? I guess you mean, May, like a pre-developed case that they're just coming to you with assistance to take?
Yeah, exactly that. Like, are people noticing that something's wrong, actually identifying what's wrong and coming with that to you, or are they coming to you with a problem and then going from there?
I guess this is about the maturity of the understanding at that citizen level.
Personally, I wouldn't say they come to us with some sort of thought through ideals, but most people know when their human rights are being impacted, and so they just come to us with that and just say, how can they do this? I have rights. What's going on? How can I stop it? So they don't get the nuances and the details, but they get the impact.
Julie, do you have anything to add there?
No, not at this stage. Sorry.
Okay.
We see what Rebecca sees, that as well, and a lot of people have the language around human rights, not the nuanced understanding. That's fine. We can help them fill in those gaps, but most of our clients have been raising breaches of their human rights with us for as long as at least I've been a lawyer, which is now some considerable period of time. So the language that people are bringing is probably a bit more frequent, I guess, that people raise their human rights. But yeah, the depth of understanding still needs a little bit of support.
Thanks, May, for your question. Now, Kat has posed a question, and this is a good one. And we've got limited time here to unpack this. But Kat's asked about the government's ability to change the Human Rights Act. The Human Rights Act. Kat, I think you mean they're like overriding it in the case of youth justice in Queensland. Does this not just negate the role of the Act? Great question, Kat. Thank you. And I think a lot of organisations have wondered about how that's able to happen. Would anyone care to comment on that?
Look, I think this is me, right? Like, this is what I was talking about earlier when I said that I had a win and a loss in quick succession due to the government changing the law last year. And I was really pretty upset about that and quite distressed about it, actually, until I had my Rebecca Ananian Walsh, who is the UQ academic, who said to me that part of the role of a human rights lawyer is to bring things into the daylight. And I think that that's helped me a little bit, even though that's not what I want to spend my life doing. Daylight's only as useful as then what happens, in my view. But I do think that she said, look, the point is the government can still deliver law that doesn't consider human rights. It's always been able to do that, and the Human Rights Act doesn't change it. But it makes it harder and it makes it more explicit. And then if there's political fallout, there's political fallout. So the human rights law and human rights lawyers are not apolitical. So it does feed into the political system. And we saw fairly immediate political fallout from the overriding of the Human Rights Act last year. And I don't know where that will land and whether that is ultimately going to improve things, because the fallout might, could go any which way, right? Like, we haven't seen the end of that. But it did make me kind of sit back a little bit and see it in its broader context, rather than it just being usually what you do as a lawyer is you run one case, you win it, then that changes to something for that person. So I don't know if that's just me trying to find some comfort that means I can keep doing my job and sleep at night. But I do think they're stepping back and seeing it as part of the whole system of how decisions are made, and the influence over decisions, and the influence over direction of policy was helpful to me. So it's not a direct negation of the Act. It's a challenge to the power of legislation, but it's still valuable.
And I go back to Julie's comment previously too about, some of the frustration there is in the sector where you do not necessarily have the resources to be doing an educative piece to your work, this extra piece that you've suddenly been given, and often needing to educate public entities about their responsibilities. That's not really part of your day-to-day, what you're resourced to do, and yet the better organisations in that front line get at that, the more, as you say, Bridget, we shine a light. The mechanism becomes a bit like a torch that we shine a light on the things that are happening, and it's a frustrating but slowly moving thing.
And at a minimum, you have a permanent public record that says when they bring in this law, they know it's going to affect Aboriginal and Torres Strait Islander children. It's going to see more incarceration. It's going to do all of these things. And we look back and we say, well, they did the best they could. We won't be doing that. When we look back on this period in history and the incarceration of Aboriginal children in this period in history, we're not going to look back and say they did the best they could, because we've got statements of compatibility that say we know we're not doing the best that we can, but we're going to do it anyway.
Yeah. There's a question here from Asha about, is there a breach of human rights for being unable to access MyGov or digital identity due to disability? Good question.
I don't know if you would say necessarily it's a breach, but you would certainly say that it's an impediment, and that the organisation that's relevant, in this case Services Australia, should be doing something to remove that impediment. And so if you had that Federal Human Rights Act, you would be able to say to them, in the Human Rights Act, there's some obligation here for you to make this accessible to all of the people who use your service, and therefore look at other ways to provide access.
Mm.
Can I comment?
Yeah, of course.
We raised an issue, but not with MyGov, it was with QGov, with the RTA in relation to a certain cohort. These were international students or people generally who just didn't, for whatever reason, have access to QGov. You needed 100 ID points, you needed certain identification to access it, and we actually argued that it put our client at a disadvantage. Whilst it's just a bond claim in the tenancy world, a bond claim is whoever claims their bond first is at an advantage in the process, because it puts the other party on notice and they have to prove and negotiate their claim through dispute resolution and ultimately go to QCAT, and the burden of proof is on the other party. So some tenants are at a substantial disadvantage because of the inability to access the web services, because they can't access QGov. And what the RTA, we wrote a human rights letter, and what the RTA did was essentially modify their process and provided a different mechanism. And I think they were looking at working with QGov to provide a different mechanism for international students and other people to access that ID component of QGov to access services. So it did create some change. Also, we had a particular tenant who, again, it was in relation to an RTA, who he had a disability and he couldn't access services due to I think he couldn't post a particular document. The RTA wanted documents by post because they wanted the original signature. And again, he lodged a human rights complaint and he succeeded in that because they didn't allow him to email it. So they did modify their services for him.
Yeah.
So I would say yes, but because MyGov is Commonwealth, again, like Rebecca says, it may be a Commonwealth legislation.
Yeah.
It is. And don't forget also that there are existing human rights type laws in the discrimination space. So disability discrimination legislation might help you already while we're waiting for the federal government to bring in Human Rights Act.
And just if I can just add too, the other thing that we're seeing in some agencies, government and non-government, is the introduction of a consumer advocate type role. And I think that's a bit of a recognition of human rights. And it's also recognising that organisations can be really hard to facilitate and work through. And so that role in most of the ones that I deal with is sort of independent and can come in there and sort of be a bit of a champion for the consumer and just sort of say, look, I can see why this system isn't working for this person. What can we do to do a workaround and so forth? So where there is a consumer advocate, I'd encourage people to make use of that role. That can also help streamline and facilitate easier outcomes.
Thanks, Rebecca. There's a couple more questions here. I'm trying to tread the fine balance between not, having enough time to get to all of these as well as finishing on time for everyone, because we've got a few other agenda items. I'm going to go to Ash's question around, is the duty to consider a person's human rights a procedural right in the Act or a common law duty? This is definitely a question for one of the lawyers and not me.
It's in the legislation. It's in the Human Rights Act. So it's the operational provision of the Human Rights Act. There's two parts to that operational provision. The first, which, because it's legislation, comes second in the Act. The first is to consider human rights, and the second is to act compatibly with human rights. So that procedural component about consideration of human rights is how all of, did everyone see that big Supreme Court matter that came through for the vaccine directions that were given in health and policing? That was a failure of the procedural limb, a failure to consider human rights that helped those people win that case.
Yeah. Thanks for your question, Asha. Now, Jack, would you like to speak to your question yourself, or would you like me to read it out?
Hey, I'm just happy for you to read it out.
Yeah, sure. Thanks. Now, this is great because it's a good example of how this network can really kind of mull over scenarios together and come up with some approaches. So Jack's asked, I'm working alongside a woman with a transgender experience. They recently were seeing an AOD worker from a funded service. The worker was referring to her throughout the sessions as her sex assigned at birth, and the focus of the appointment was not focused on AOD counselling, rather a negative focus on her gender identity. Which act do you think this could be breaching? She said her drinking increased as a result of the counselling sessions. Open to the floor, and also, all of our participants here, if you've got something to add too.
Is the counsellor a worker in a public entity? I think that's where you would first start. Yes. Yeah, I'm just not sure what the acronym AOD means.
Oh, alcohol and other drugs. Sorry, Julie.
Oh, sorry.
And yes,
Sorry.
This is the thing, isn't it, about the sector? They're all, and please, everyone, feel free to ask what the acronyms mean. Often they come up and I don't know what they are either. So thanks. Thanks for bringing that to my attention, Julie. I should have actually said the whole term.
I don't know. I'd probably start by having a general conversation or a discussion about the reference or the focus on the gender identity, or the negative focus on the gender identity, before you go straight into the Human Rights Act, to get some clarity, whether it's just a misunderstanding or a mistake, or yeah, but I would say you could use the Human Rights Act in that respect, or anti-discrimination. It just depends on the facts. Yeah, what do you think, Bridget?
I think this is it gives me an opportunity to talk about the interaction between anti-discrimination and human rights law. So I think that where you've got less favourable treatment of a person because of an attribute that they have, or where they're being required to comply with conditions and terms they wouldn't have to comply with, or that is difficult for them as a person with a particular attribute. So your person has a protected attribute in their gender identity, so they may experience things in different ways, and that if that experience is significantly more negative compared to someone without that attribute, that's also discrimination. And when you've got discrimination done by a public entity, often you've got human rights in breach as well. So usually you'd raise both of those two things at once. You would say this is discrimination and it's also a breach of a person's human rights. This person could get assistance from the LGBTI Legal Service or a community legal centre or legal aid. So it would be something that a lawyer would probably be useful for a lawyer to have a look at. There are a bunch of options in how they might approach that complaint, and some factors which are not known, such as whether or not this was a psychologist or what sort of agency it was, that might affect which legislation might apply to it, whether it would be the Sex Discrimination Act, the Anti-Discrimination Act, the Human Rights Act, and things like that. So I would say it on its face, it has features of discrimination, features of human rights limitations, and it is something that there are plenty of legal services out there that would be really happy to speak with this person about. Yeah.
Thanks, Bridget. Thanks, Julie. Anyone else want to jump in? Was that helpful, Jack?
Yeah, it was really helpful to hear all that, and I really appreciate everyone that sort of jumped in and spoken to it. I guess my sense after having quite a deep conversation with this person is that it wasn't something that the counsellor, they knew what their gender was, but they continued to misgender them. And when they went to report it to the service, the direct person that they were reporting to was the person that was the counsellor. So there was no sort of complaints process. It went straight to the person who was their counsellor. So yeah, just I guess looking for some advice around where to next, I suppose, to sort of support this person in a space of advocacy.
Probably take it straight to the commission.
Yeah, so I was just going to say, depending on what the health professional is, whether they've got a peak body that they're also a registered member of, thinking about a complaint that way.
Sorry, Julie, were you going to say something there?
I was just going to say, if you take it to the Human Rights Commission for conciliation.
Yeah.
It does look like the Human Rights Commission would be the best option, but I would recommend getting some advice first to make sure about that.
Yeah. Thank you. Now, I am going to come back to our panelists and start to wrap up the panel discussion by asking you to share with us an anecdote, an example of where the Human Rights Act has really helped you advocate for the rights of an individual. Who'd like to go first?
I'll go first. So in practice, we do it every day. So we do it against agencies, whether they are obliged to apply the Human Rights Act or not. We just work with it as if they are. And so all of our workers will be having conversations with agencies, whether that's aged care, whether that's public trust, Queensland Health and so forth. And we're using it all the time. We're saying this patient, this client, this consumer, whatever, they have rights under the Human Rights Act to such and such and such and such. They have a right to privacy or whatever the relevant issue is. And we're sort of putting it on them to upskill themselves and come back at us a bit, I guess, because even if we know as an organisation they're not technically obliged under the Human Rights Act, we also know that a lot of them don't know. And so we will use it in that way. Where we've had systemic results is a number of the organisations that we deal with, such as QCAT, Public Trust, Public Guardian, Public Advocate. It's been a champion of it as well. Those agencies have had a number of stakeholder engagements with our sector to look at practices. And I know it's not perfect, but at least they're having the conversations with us, and at least they're looking to improve process and routines. We've had them with, say, for example, the public trustee has incorporated now a new financial independence pathway. It used to be the mindset that once you're a public trustee client, you were there for life. And the Human Rights Act got them to recognise that actually they should be doing more to release clients wherever possible. And so that's what we champion all of the time, is get this client on your financial independence pathway, sing it from the rooftops, champion how well they're doing, go to QCAT and pronounce that they're a success story, get them off your books and so forth. And so Public Trustees has been receptive to that conversation, and we work with them as much as we can to get them in practice to roll that through their whole organisation.
Thanks, Rebecca.
I'm happy to go next. I'll give you 2 examples. I'm trying to think of relatable ones because I'm not going to talk about how we piggyback it in our litigation. So one is our social workers use the Human Rights Act all the time. So we have what they'll do is if they're writing a letter for housing or there's some kind of access to services, they'll run it past a lawyer and we'll add some human rights considerations into those letters. So it has helped them to boost the efficacy of their advocacy because now they are able to draw on specific legal rights. Social workers understand the Human Rights Act like nobody's business. It's just like breathing to them. So they have, but what it does is give them section references that go with the things they already were saying. They were already talking about this stuff. It now gives them a legislative reference to add into that. So it's been really helpful for the social work team. And they are enthusiasts of the Human Rights Act because it gives some weight to the way that they were already engaging. For my own example, what I started doing probably a year or 2 ago was if I'm ever doing and I don't know if a lot of people would do this, some probably do, if you go before a parliamentary committee to talk about a legislative reform, or if you're writing a law reform submission, I find it really helpful to use the structure of the human rights considerations to walk people through how they're supposed to be approaching stuff, and in particular to walk them through maybe thinking about things in a different way to how they're currently thinking about them. So I find it gives some stability, because I think when I do that work, I try and tell a story, and some people are really receptive to the story, and some people find that to be not sufficiently structured or legal or grounded. And so the Human Rights Act gives me a way of structuring my storytelling in those environments to bring along people who might be more influenced by law and structure than stories. It just you can combine the 2 things. So those are the 2 examples.
Great, thank you, Bridget. And Julie?
My examples would be, again, individual advocacy. We advise write the human rights complaint early due to the length of time in responding and due to the fact that you may not get the response you want. So you need to take that next step quite early. So we use it with our various government entities on an individual basis. And I've also used it recently in a meeting with a government department. There were regulatory services head of department talking about his interaction and regulation of community housing providers. So we raised the fact that these community housing providers weren't responding to human rights complaints. So, this head of department would send his workers in to do some checks and investigations into how these housing structures were run and compliance with various legislations, but they never thought about compliance with the Human Rights Act. They wanted to check how they complied with tenancy legislation, whether they evicted tenants or provided adequate notice periods for tenants, whether they subverted other legislation that they were supposed to comply with. But until I raised it in a meeting saying we're getting very little uptake with our human rights complaint, he just didn't really think about that as something. So that they go in and they look at the various policies and procedures and complaints procedures of these community housing providers. So that was a creative way. So I guess we're looking for creative ways to bring it in to our stakeholder meetings to, I guess, educate a bit further.
Thanks, Julie. And thanks to Rebecca and Bridget for all of your contributions and thought-provoking examples and discussion this morning. It's been really useful. I can see a few people in the chat have said that it's been really insightful for them. So thank you very much. to all of you for that. And I just wanted to mention, for those who may not be familiar with the resources, that the Community Door actually has a human resources library, and one resource which I'll just link in the chat, and one resource in particular that organisations have said to us they use quite often is the 4-step process for proper consideration. It's a worksheet that you can use. The organisation in particular we were speaking to last week said that the more their workers use it, it's just becoming, as Bridget alluded to, like something they're living and breathing then every day, the more you use that process. So if you are looking for something in your organisation to support the proper consideration process, do recommend having a look on Community Door at the resources that are available. You may find something that's useful there for your organisation. There's quite a few things there. We've touched on lots of things this morning. A feeling or a word that came up a few times was frustration, the frustration of the slow process, the frustration sometimes of resourcing, that when new legislation such as this comes in, there's an educative piece to be done that's not necessarily really the core responsibility of organisations, and yet it often falls on the shoulder of frontline organisations to do that piece, and being held to standards that particular agencies don't sometimes hold for themselves, and that can be a frustrating piece of this work. And yet we have heard about those really hopeful cases and the development of our capability as a sector to engage in advocacy. And we have seen not only individual wins, but systemic wins as well, and that can be a slow process, but it's something that I encourage all of you to either, depending on where you're sitting in your organisation, you consider collective advocacy, and where your organisation may be able to engage in movements with the rest of the sector. We've seen a lot of movement in housing, for example, and that's really only been because of collective voices and collective work as far as advocacy goes. So I encourage your organisation to consider how you might be engaging in that, and whether or not there's space for you to do that as an organisation. We will be sending out a post-meeting email after today with some resources and things for you to consider if that's, and I encourage you to look at those resources. And speaking of engaging in advocacy and using your voice, we have got some time in the agenda to have a quick look at some upcoming consultations or reviews, which we'll have a look at now. We have, first off, I think, Bridget, you have already, thanks Lauren, you have already talked briefly about the anti-discrimination bill. Would you like to say anything more about that, Bridget?
I just wanted to let people know that I'm working on that very intensively over this week and next week. It's the main thing I'm doing. I'm happy to see if there's things I can usefully provide to other people as they're going about making submissions to that. I'm happy to try to help where I can. I did just want to say, if you haven't already had a look at that, I would really encourage you to do so. The government appears to be enthusiastic about making quite a substantial change to the anti-discrimination regime. However, it has been written in some haste, I think, and there are some things in the way that it's written that I think are going to have a different impact to what they're intending. We've got until the 22nd of March, so next Friday, to address all of that. So to tell them, I don't think this is going to do what you think it's going to do. For example, and this is relevant to a lot of organisations, there's an affirmative action provision which allows you to take affirmative action to advance the interests of particular groups of people. So we see that a lot in recruitment, where you will hire for women, or you may wish to hire for First Nation staff. The way that it's drafted currently, it will not achieve that for First Nations people. It will achieve it for women, but it will actually limit people's capacity to hire specifically for people of a particular race. And so I think that's not what they're intending to do, and it will affect organisations on the ground who engage in affirmative action practices in their recruitment processes. So there's a bunch of things like that through the existing law. And I would say if you do affirmative action at all, if you work with a cohort of people who usually rely on the protections of the anti-discrimination legislation, have a look at it and just think about how it might operate for you and how you might engage with it. If you've got questions, I'm happy to field them. I can also deal with those offline because I know we've only got 10 minutes left. But yeah, so a big change for us. And anti-discrimination law is human rights law, but with real teeth. So it's really important that we get this right. Once in a generation opportunity, I think. The last one was written in 1991, so we can expect it'll be another that long again until we get another opportunity to revisit this. So now's the moment.
Thanks very much, Bridget. Great encouragement there for organisations to engage in that process. We have the Sexual Violence Review Board Bill, and I can see that Laura and I both were thinking the same thing and both posting links in the chat at the same time. I'll leave that to you, Lauren. I won't meddle with that. That's one that we encourage you to have a look at. Lauren, did you want to say anything about that, or just mentioning it?
Oh, hi, everyone. Yes, a big part of this network is sort of encouraging people to come together in their consideration of major opportunities for law reform and contributing to consultations. A really important part of the Human Rights Act is to ensure that legislation is compatible with the Act and to think about that really meaningfully. And it also creates a really great framework for responding to these opportunities. Being an election year, the turnaround times are fairly tight. So the Victims Commissioner and Sexual Violence Review Board Bill is actually due for submission this Friday. But there's a number of consultations open at the moment, but I just wanted to particularly highlight a few that connect really closely to human rights. So another example we have here is the Education General Provisions and Other Legislation Amendment Bill. If you have an interest in that, you might be interested in looking at the Right to Learn campaign, because this bill has a lot to do with how things like suspensions and school absences are managed to ensure that children are accessing education. We also wanted to just give a quick plug to the Stage 2 rental law reform process, which is coming up, partly because we have the privilege of being joined by Tenants Queensland today. This was an options paper that was introduced in May of last year. The government has now made a number of commitments on what that might look like, and we're going to be expecting legislation introduced hopefully soon. If you have an interest in staying up to date with that, we will be engaging with it very closely, as will Tenants Queensland and the Make Renting Fair campaign. So we just really wanted to encourage the network to be aware of these opportunities and to create that space for people to discuss them together collaboratively. I'm very mindful that a lot of people engaging in policy work might be working in a team of one, or may not have a lot of people sitting next to them to bounce ideas off of. So that's a really important part of this group. And I'll just invite Julie to if you'd like to make any comments about the Stage 2 rental law reforms, but absolutely no pressure if, as you know, we are getting closer to 11.
Yeah, we think it's quite positive. There's quite a large number of reforms proposed. There's one about the code of conduct for the rental sector, and that may involve lessors, agents, and possibly tenants, which Queensland hasn't seen a code of conduct for the rental sector or for agents for quite some time. And many tenants are calling for such a code to exist due to various behaviours that are existing out there at the moment. The rent bidding proposal is quite promising. Again, it goes further to prevent rent bidding. I can't go into the detail, but yeah, we're seeing also the government, along with these stage 2 rental reforms, the government's launched the Homes for Queensland paper, where they're extending their grants and subsidies. They're also expanding the department in terms of employing more workers, Rent Connect workers and housing workers, their frontline officers. They're increasing those worker numbers, and they're also hoping, and this is a big achievement if they pull it off, they're hoping to build 1 million homes by 2046. They've put these buckets of money, so you can read about it in the Homes for Queensland document, which is on the website, and you can engage in the reform process by going to the Making Renting Fair Queensland website. And as the reforms are released, you know, that they are drafting as we speak, as the reforms are released, we'll post ways of engaging on the Making Renting Fair Queensland website. Thank you.
Thank you so much, Julie. And yes, if anyone does have an interest in getting together about a particular inquiry, you're welcome to reach out to us. We might be able to host a slightly less formal Teams meeting, or you know, connect a few members together. You can contact us through humanrights@qcos.org.au, or also the research inbox, which I'll pop in the chat. Yeah, we're very keen to help build those relationships and that sense of a network that can collaboratively discuss these ideas. Really interesting to hear Sky's thoughts on the EGP Act, and I think it's really important that people can help to raise those concerns when we see important legislation introduced. So thank you, Sky, for sharing that. I'll hand it back over to Stacey.
Sure, thanks. And I'm feeling really impressed with everyone right now for the fact that we've got 3 minutes left, and we're exactly 3 minutes left for the closing and summarising of the meeting. So this is great. And today's meeting has really demonstrated the success of the purpose of this network, which is really to facilitate that conversation and discuss the real matters that are coming to you every day. So thanks so much to all of you for being a part of that, and especially to our panel speakers for sharing your insights and your expertise with us as well. Really appreciate it. Now, our next meeting will be in May. As I said in the beginning, we have scheduled meetings bi-monthly, and that's we have done that to allow gaps between, because we know inevitably things will come up that we will want to quickly meet with network members about, particularly consultations that often have tight turnaround time. So we've given us some space, given ourselves some space between meetings to allow for that to occur. In May, we are going to focus on supporting the rights of older persons in the lead up to a date in June that really looks at supporting rights. Oh, May, did you have a question? Oh, you're clapping.
No, I was trying to react.
Fantastic. As we mentioned, this is a participatory network. We really would like it to reflect the things you're interested in, make space for the discussions you would like to have. So if you have something to add to the agenda, if you've got ideas as to the things you would like to see this network focus on, please email us. We're really happy to chat about your ideas. And if you have questions and you'd like us to connect you to the right agency, or would like to just have a discussion about what's going on for you, we're always open to hearing from you. So please get in touch. We will send out a post-meeting email with some resources and information from today. And I am hoping that I have correctly launched a poll that should appear on your screen now before we close off the meeting, which will just ask you how you found the meeting today. But please go well in the rest of your week. Enjoy the rest of your day, and we really hope to see you again in May. We will be sending out a registration link as soon as we've got it ready for that meeting in May and the date. So thanks to all of you for your time, and we hope to see you again on our screens soon.
Thanks so much.
Thank you.
Thanks, everyone.
Did you want us to stay on, or are we right to go as well?
Oh, well, I just wanted to say thank you to you
No.
for your expertise. That was wonderful. Thanks, Bridget. Really appreciate it. And
Yes,
good luck
thank you so
with
much.
the
It was
huge
really
amount of
great
work you've got.
Thank you.